We are live. Welcome, Bonnie and Chris, and hopefully welcome everybody else that will be popping in here. Excited to be talking about the fiduciary rule again. I think we have been doing this for about the last 15 years, and so it's always fun to come back to the new version of the Department of Labor fiduciary rule. Bonnie and Chris, I think maybe the best way to kick off real quick at the start is just hop over to you two, maybe quickly tell everybody who's on here a little bit about yourself. And Bonnie, maybe just set up how we're going to approach this one here today. I know we're going to try to get people in and out pretty quickly, so not try to delay it too much, give you some really high overview points. And then I know we're going to do a deeper dive later this week. But Bonnie, I'll pass over to you first.
Awesome. Thanks, Jamie. Glad to be here and talking about the fiduciary rule, depending on how you describe it, either version 3 or version 4. And we'll probably talk more about that tomorrow. So my name's Bonnie Treichel, partner of Endeavor Law and founder of Endeavor Retirement. And I'm joined by Chris, our director of compliance. And as you mentioned today, I think the point is to give people like their kind of, 4 to 6, maybe 5 quick talking points on the fiduciary rule, why they should actually be paying attention to it. I get a lot of advisors who say, hey, if this just keeps coming and going, should I even care? What does this even matter? So we'll give you a couple of the reasons you might actually care to pay attention to it. And then tomorrow, if you want to tune back in, we are going to, at 2 o'clock Eastern, have a deeper dive, actually share some slides. People can download those and take them, rebrand them, use them on their own to go deeper into the fiduciary rule itself. Chris, anything you want to add from the intro perspective?
We're good. Make it short and sweet.
And if you do have questions, I do believe that, when you're in here, there's a comment section. If you write them in, we'll be happy to answer those as you go. So one of the things, too, as I look out there, I'll kind of maybe give my first takeaway, Bonnie, and I'd love to maybe Chris and Bonnie hop in on this one. And I'm going to take it from the question that I've already gotten from somebody today, which is, well, what's the likelihood this rule stays in place? So I believe it's going to go live in September is the goal right now. It will, without any doubt, like the previous rules, be challenged by somebody. I think we've already seen a couple people put out statements today on blogs and things about how they're not in favor of it. So not super unlikely. Fifth Circuit before came out and said, hey, look, your rule was too broad. Right? Way too broad. You don't have the Department of Labor this type of regulatory authority. Eventually didn't get appealed up and defended. So we don't know exactly how that would have done further up in the court system. But my takeaway was this was very, very scaled back. A lot of the, I'd say, hold up or kind of challenging points, like if you remember, the best interest contract, not in this version, right? The website where everybody was going to have to put all their compensation models, not in this one. The fiduciary liability on insurance companies that were overseeing agents, not in this one. I'd say those were 3 of the bigger sticking points from industries that push back on this. So I think, to me, much simpler version of the rule, obviously a lot less pages too, which probably goes to that. But take away from from your first view of it, maybe Bonnie and Chris. I know we never know what courts will do, but my first take was this is pretty simple. Doesn't have a lot of the hair, I think, that the last, again, which version, but the 2016 version had with it.
Totally agree with you. I think this is a much a simpler version. And I think the DOL, one of my key takeaways was like the DOL is prepared and armed for litigation. Yes, there's absolutely going to be lawsuits, 100%. And I think if we think about the impact on the insurance industry from this final rule, there's going to be litigation, but the Department of Labor, in my read of it, and what I recall from the comparison to the 2016 version, is that there is considerable time spent in the preamble laying out all the reasons that this is so different from the 2016 version and how this is a much more narrowly tailored version. And so when we're talking about this, the whole key is that, the DOL can't go beyond their authority, which was given to them by Congress, and that they have not done so here. And they continually identify all the reasons that this is different than the 2016 version.
Chris, any takeaways on that?
Definitely. I mean, I agree with Bonnie's takeaway there. I also enjoyed how they really matched it up to the other regulators' definitions and a lot of the other like other standards that they've got. So it's been much more streamlined, it seems.
Yeah, that was an interesting note, right? They specifically called out that they aligned this with the SEC rule that came out, and that also they paid attention to the NAIC, which I don't. Now, again, it's been 8 years since the last version. I don't remember much mentioning of the NAIC rules back when the 2016. I think more of the attitude then was like, we're federal, we don't need to pay attention to these state level rules, we're going to run forward. This time they were much more cognizant. They even called out, I think, the New York rules, which deviated from the NAIC and kind of adhered a little bit more to a federal standard, but saying, look, it's actually all going to work together, less conflict than there was originally. Okay, I think that one of the next points I'd love to hop into is the most important thing is what this has always been about is defining what investment advice means under a risk, right? I mean, that's the entire thing comes down to two little words. What is investment advice? Bonnie and Chris, you want to start off, where did we land, right? What's different from the existing test and what is coming out here in the future? Who's going to qualify as giving ERISA covered investment advice?
So we're not going to get into the weeds today on that because I think we've got a whole series of slides we're going to go through tomorrow on that. One of the things I think is interesting, right, is that this is the key things in my mind is that this is an objective test and that this is going to be based on what a reasonable investor would believe. So I kept writing down things like this is based on a relationship of trust and confidence and a reasonable investor. I can't tell you how many times that's listed throughout, right? So those are key things to keep in mind. Another key thing to keep in mind is that sometimes when you're looking at guidance from the department, the proposal doesn't have that many differences from the proposed to the final. There are, from my perspective, there's quite a few differences, right? In the actual, the key thing to keep in mind is that the 1975 test, 5-part test, that is gone. So that is out the door. Then we had this proposed test that we saw in the proposal from October 31st. That is somewhat intact, but again, there's definitely changes in what we're seeing in the final rule. And it's really based on either someone tells you that they're giving you advice or then this kind of series of parts. And it's really based on what would a reasonable investor believe. So they're giving you investment advice, it's for compensation, and it's based on this ongoing relationship. And the fact sheet lays it out really nicely too, that was published yesterday. And we'll dig into that more tomorrow, but it's based on what would someone believe?
Yeah, Chris, anything you want to add there?
I think she nailed it. The only thing I'm concerned about is really getting that definition down as time goes on.
Yeah.
That'll be a fun one.
One of the, I think one of the biggest takeaways to me was, and this was expected, is that, in the past it was the regular basis or whatever it was part of the test, which is gone. So it can be one-off advice would qualify now. And I think that's been always a thematic of all of these variations would be that the seriousness of advice is really what matters, not whether or not you would recommend a second rollover. It's recommending rollovers and product placements are important. And that while they might be one-time recommendations, they are investment advice, they are covered. And, it's a little bit different. Now, one thing I noticed that's different from the 2016 variation of all this is that it does need to be right in the regular course of your business, which actually didn't exist in that 2016 one, which there was a lot of questions, like if you were, essentially a financing arm of a car dealership and told somebody to cash out their IRA to pay for the purchase of a car, you probably triggered investment advice in that situation under the previous rule that was said to be too broad. Here, that's gone, right? You really do have to be in the, advice giving world, the investment world, the financial world to probably trigger this. So that kind of those types of situations where somebody might accidentally provide investment advice and they're getting paid likely wouldn't trigger a fiduciary requirement. Is that kind of both of your reads here?
Yep.
Yeah. I mean, it's the change from the one time, and I think that's going to be a big deal. And especially, and we'll get into this, I think, again more tomorrow, but the idea of kind of what I'm going to call platform providers, or when a wholesaler gives you that kind of one time hit and run advice that wasn't advice before, that is becoming advice now. I think those are all things that we'll get into. Another thing to distinguish would be, I'm going to call it the hire me exception, or I think we'll talk more about that, or kind of when you're just giving sales communications. Those are these areas that they get into in the preamble, which again, we'll talk a little bit more about. And it's all going to be taken in the context of, as Chris pointed out, what does that look like in the overall context of the definition in totality based on the facts and circumstances as an objective test.
Chris, anything there?
Nope.
So I think
keeping it short.
I think Chris, Bonnie had you reading the updated PTEs, right?
Correct.
So we've got updated PTE 8424 and then the 2002-02, both updated here. Who wants to start with these? How did these change? How are they different from what we've had in the past? And I think also who's going to be impacted by these? That's probably maybe the biggest one, right? Is because a lot of people on here are saying there's a lot of things changing. Am I really being impacted? Am I not being impacted? Those prohibited transaction exemptions are often the ones where it's really driving the true impact for advisors or agents.
Bonnie, I can jump in here. The impacted institutions really hasn't changed significantly. They've added, I believe, the non-bank trustees and custodians. So those will be included in this area. But otherwise, the previous release is consistent net with this one. Changes that are occurring with this rule, majority of it is very similar, minor changes for a good portion of it. And then they've expanded some other areas. I think the biggest is going to be your disclosure requirements, closely tracking these other regulators. So, I mean, you're going to have quite a bit of disclosures as we previously did, but it's going to have to match up to the SEC. You've got your disqualifications that's now 10 years limited, which is nice. And then you've got streamlined exemptions for the financial institutions with the RFPs under the ERISA through 38. So when it comes down, and then of course the record keeping requirements, they actually stayed the same, which is if you've already got your established procedures, be convenient. And then, the fun one, I enjoyed this. They used regular best interest too often, and so they've now switched it from best interest and they've defined it as care and loyalty obligations. I enjoyed that immensely. People were too confused based off of how often best interest was listed out. And that's PTE 2020-02. The other one is pretty also standard, hasn't changed significantly.
Yeah, for 8424. Bonnie, anything you want to add about PTE 8424? And if people aren't super familiar with that one, often I think the best way that's more of the individual agent exclusion in that case, to be able to sell commission-based products under the rules that would otherwise be prohibited.
Yeah, I think for purposes of today, we'll just kind of leave it as if you're thinking more in terms of, individual advisors who are thinking about the rollover context, or RIAs thinking about rollovers, you're probably going to be thinking more in terms of PTE 2020-02. If you're thinking about insurance, you're probably going to be more on the 8424 side. So those are probably the two camps you'll be thinking in. And tomorrow we'll get into a little bit more of the weeds of how those change. Probably on the 8424 side, that's more where the changes have happened. And again, I did drop the link to the fact sheet to the comments. Even in the fact sheet, it gets into a little bit of those high level changes in 8424, just in kind of 3 short paragraphs in the fact sheet. And then we'll get into a little bit more detail. 2020-02, there were changes. So I would say, that'll be something that you'll be on the lookout for from your home office for what some of those nominal changes are. Nothing substantial, but there will be changes there. So again, in the comments, we dropped the overall links to all the packages for anyone who wants to read all the pages, or even just the fact sheet, which again, I think those are nice roadmaps to give to clients.
And we had a question in there from Kevin Clark, asked a good one, which I think is right, that the Department of Labor has been trying really hard to impose Title I standards over across the individual retirement accounts. Do you want to take that question there, Bonnie?
When I started speaking on the rule back in 2015, when we saw that proposal come out, and then it was, became final in 16, one of the things I used to describe is I described it as like an umbrella. And I started saying, the Department of Labor basically in 16, they were bringing more people as well as IRAs under this umbrella. And I think, Kevin's point is well taken, that it's about expanding who's under that umbrella in a way to basically, provide protection. And I think there's a few places under the preamble where it just talks about like the biggest decision one will make is that decision to take money from their retirement plan and put it into an IRA. And so I think, Kevin's point is well taken, that there is an effort to protect investors in that IRA. I don't know, Chris or Jamie, if you disagree.
Definitely agree.
Yeah, and I mean, look, that goes back, I think, to Kevin's question, really to a mandate that occurred at the end of the financial crisis, right? Which was, how do we protect these ERISA assets when they move out of ERISA over to the individual retirement account world? And it's kind of spurred on this entire piece. The 2016 legislation, I'd say, even went further, or not legislation, but rulemaking went further than this one did into that, and really did try to regulate that area that previously kind of fell a little bit outside of here. But that is part of the goal. I mean, that's been stated by the White House multiple times in their releases, the Department of Labor, and I think it was 2009, which was that very first congressional hearing about it. Or 8, but in that time frame when they said, hey, we need to go look at this. And they really did charge the Department of Labor with that back then. So there's a little bit of the, how far should they go? But that was something that came out of the financial crisis to go really protect those assets for Americans long term. Now, you take that, one of the pushbacks that's constant here from parts of the industry is that by requiring this standard, higher regulatory requirements, more disclosures, more paperwork, it might push companies out of this space. I did believe that the BIC contract exemption, some of that could do that. I don't know that I'm buying that in this world, looking at this so far. Do I really think people are going to exit the retirement asset space? I don't think so. Most of those companies that have talked about that for a long time, really have steered more into this space. Most of them have fiduciary services at this point too. Like, that's a really big change over the last 14 years in the industry. I don't know that I see it. Kevin's got good questions for us today, so I don't know if we'll probably try to go for another couple minutes. If we get some other questions, I'll read that one out too. What does it mean that IRA holders will have the ability to use courts like a 401k participant versus arbitration? Bonnie, do you want to tackle anything around arbitration versus the court system? I mean, this was a huge part of the 2016, right? Just massive, the class action lawsuits, all of that. But that's been pared back a good bit from the 2016, especially excluding the insurance companies from that liability for multi-agent oversight.
Yeah. And I was looking for where they address this specifically in the preamble, but they specifically hit this head on in the preamble that unlike the 2016 version, which did establish that private right of action, that's not the case here in the same way as the 2016 version. So, Kevin, if you tune back in tomorrow, I'll make sure to hit that specifically, but that is specifically addressed here in the preamble that, it is different than the 2016 version with that best interest contract, which creates that privative contract and that private right of action.
Another question here. Any implications for non-ERISA plans with this ruling?
That's a Good question. So, this is for ERISA covered plans that are subject to, this is all subject to ERISA. So I think a lot of times state law then follows suit and tracks ERISA very, very closely. But this is all subject to ERISA and to the tax code. So when we think about how, we have the Department of Labor, which has the responsibility for issuing regulations and prohibited transaction exemptions under 4975 of the code. So we've got the tax code that intersects with ERISA. But I guess if we're thinking about like a governmental, like a municipality or something, Jamie, I'll look to you to kind of weigh in there as well if I'm missing something. But
no, I think the main thing you hit, but probably goes to Katie's question, was that there are not a lot of automatic impacts, with one caveat. I will mention that, but I don't know how normal that is. But I have seen it a couple times where the non-ERISA documents actually state in it that they follow changes to ERISA from duties. So there could be, but that's going to be plan by plan. It shouldn't have a mass implication. Now, do remember that some of the non-ERISA plans can be rolled over, though, to IRAs. So it would have an impact in that situation as people are leaving plans. So I think those would be two areas for me that are sitting out there.
Yeah, that's a great point. And then I know Steven's got a question, which maybe, I don't know, Jamie, if you want to take that as kind of I know you know that space.
Yeah, I know Pantera pretty well. Previous firm used Pantera. I'm a big fan of Pantera. There are some challenges that they're facing just with some custody rule issues out there. So there's been some hesitance in some firms to move forward with it. But, Commonwealth, one of the largest BDs, just announced rolling it out a couple of months ago. I see more and more adoption of that. I think it allows advisors to be more comprehensive on their planning, get paid for it, not trigger the custody rules of taking custody. And unfortunately today, too many advisors are still logging in with client usernames and passwords in those situations, which really just should not be doing. We know it happens out there in the world. You could actually go into the litany of things you are violating with that. There's actually there's some federal computer fraud rules that you would be violating in addition to custody rules. So it's really a world you shouldn't go to. But I'm a big fan of the held away asset billing options like Pantera. At Bryn Mawr Capital Management, Bryn Mawr Trust, where I am today, we're in the process of vetting them through our third-party risk right now. So we don't currently use them, but my goal is to roll them out here in the future. But we have to see how our team looks at that. So it's kind of an aspiration for me here, but I am a fan of it. And then Bonnie, you mentioned it will be recorded tomorrow. So Bill, if you sign up for the link, you will get a recording of it and be able to download everything. So as we said, we want to keep this pretty short. We're coming up to about 25 minutes. Maybe closing comment on this and much more detailed slides and everything, breaking it down next week, tomorrow. Bonnie, Chris, closing comments around our 24-hour out, not even take on reading this rule and not getting as much sleep as we would like.
I think my closing comment would just be that, I don't think there's anything earth-shattering in it. I think a lot of the retirement plan advisors that I work with today, it's much of the same for them. 96-1 or the education carve-outs are still intact. A lot of things are going to remain the same, but I look at it as just an opportunity to continue to reinforce with your existing clients, like, hey, I'm going to continue to be a fiduciary. I've been a fiduciary before. These other guys and gals are going to be new to come under the umbrella. We've always served you as a fiduciary. We're going to continue to serve you as a fiduciary, and it's a good sales opportunity to just continue to reinforce the service you've been providing.
Yeah, and I want to echo that. That's a great one. On the compliance side, it's going to be, if you've already established the procedures surrounding a lot of these PTEs, the nice thing is that you won't have significant updates.
Well, I think that's a reassuring message to a lot of people that the best interest contract that everybody was working on before felt super onerous and not workable for a lot of places. But this is I think a much more workable solution. We're a couple months away from getting there, and I believe there's a 1-year kind of stay to apply to comply with some of it after it goes live too. So even in that sense, everybody doesn't have to be ready come September. It'll really be kind of a year out from September. So just even from, how quickly firms are going to have to move on this, we have a little bit of space to get this done. Also something that allows really the Department of Labor to better probably defend the rule ultimately as this moves forward. Chris, Bonnie, thanks for hopping on here. I know we got all this set up within 24 hours, so really appreciate it. Insights you brought everybody, deeper dive slides, downloadables, everything like that at 2 p.m. tomorrow, which Endeavor will be running. Thanks for having me on too. Everyone stay safe and healthy, and we will talk to you all very soon. Appreciate it.
Thanks, everyone.
Thank you, everyone.